the role of every teacher for which they have shaped our career and for which we are today. So as well, wherein we celebrate the Engineers Day on account of the birth anniversary of Sir M. Vishweshwaraya. So in this month of celebrating Teachers Day and the National Engineers Day, I would like all of you to give a big round of applause to all the teachers who have made your life for the present. An entrepreneur is a teacher within himself or herself. Teachers make the best entrepreneurs, the best innovators, fundraisers, and problem solvers, and these are all often found in the front of the classrooms. Engineers by qualifications and the individuals who are building engineers to the world and the intellectuals who are solving the problems like engineers do. A happy Engineers Day to each and everyone in the house. It takes less time to do things right than to explain why you did it wrong. A perfect quote to go on with the legal nuances session for today. On a fun, people who are in relationship, the letter L stands for love. And for those who are entrepreneurs, the letter L stands for legalities. Saying this, I heartily invite Dr. Mahesh Rao, President TiE Mysuru, to welcome the August gathering.
I'm not able to hear you guys. Come on, have some energy. Good evening. Today is supposed to be what our teacher, Mr. Kishan, said. This month is supposed to be Teachers' Day as well as Engineers' Day, right? So today we are going to have a masterclass teaching you about the nuances of understanding how to read a term sheet and how to worry about financing. Okay? Some of you have been very lucky to get a term sheet from an investor and you haven't figured out what are the nuances in there, what are the fine print, how do you read it, how do you make things work, right? So that's what you are looking at. And today's masterclass, this was in works for almost 2 months. More than 2 months? Yes. So we have been talking about it and we have been pursuing it and making it happen. Took a little bit of time because of various other reasons. And even today's program was a little bit shaky because he was not free at that time. And then we convinced him that please do come because next week we have Milan program and thing to go in there and meet up with one of the companies in Mysore. I have a short video which I just wanted you guys to see, and that's the reason the thought occurred to me after coming here. As usual, an innovator, a thinker will always have last-minute thoughts which they want to share, and that's what happened to me. And sorry for keeping you waiting. And can you share that? So the reason for sharing this is that I went there a few weeks back. Go back in life to 1946, 1945-46. Sir M. Vishweshwaraya went on a world tour and came back to India. He was supported by Maharaja of Mysore. And that time he went and he came back. I may be wrong in the age, year, but that doesn't matter. That is not important. Before independence, that's all what is important. He came back and then he was asked to go and visit this beautiful falls in Jog, very close to my native place. He went there, he visited, and what did he utter? What a waste. That was his utterance. We all see this beauty and we are all mesmerized by it. Sir M.V. said that it's what a waste. And what did he do? He convinced the Maharaja to put together a dam, Hire Bhaskar. That dam is now immersed in Linganmakki. It was a dam before that. And that generated 11 megawatt of energy, which was supplied to VSNL, what we call it today, and made it viable. And this is what we are talking about, Sir M. Vishweshwaraya. Most of you know about Sir M. Vishweshwaraya, about KRS Dam. What you don't know is this. You might not have heard of it, you might not have seen it. He is like a god in this part of the country, the old Mysuru region, but he is also a god in here. Okay, that's the point which I wanted to make when he said about Sir M. Vishweshwaraya. That occurred to me that we forget all the contributions of him, which made the Vishweshwaraya steel a viable alternative in Karnataka. Of course, it closed down again. It's going to be revived. Yeah, he can't be blamed for that. He made it viable, but the labor problems or whatever that made it close. But that's a different story. The point which I'm trying to say is very simple. Somebody who is an entrepreneur always thinks of what could be. What it is today is not the point which he is thinking about. What it could be. When Sir M.V. looked at it, he thought about what it could be. What a waste happening now, but what it could be. Look at Sharavati generating today so much of electricity. It's almost about something like about 760 megawatt of power, what it is generating. Okay? So that is the kind of power it is generating in Karnataka. For a long time, Karnataka did not need any other kind of energy. We were exporting energy to other states. Today, of course, with industrialization, we need a lot more energy, and we are going into nuclear, thermal, various other things, but for a long period of time. Okay? One other thing which he did in that part of the country was that when he produced that much energy, there were a lot of rice mills which were, it's again, a lot of rice growing area. They were not able to function properly. He said that, we will provide electricity to that area and make that work. So there were multi-use of this. For those of you who know Kannada really well, there is a storybook written by Dr. Gajanan Sharma, who used to work in KPTCL or Mysore Power at that point in time, called Punarvasu. Please read it. It's the story of Sharavati. It will be a wonderful story for you to read. Okay? So it's very heart-moving story. The people of that region, how much trouble they had, how much of sacrifices they did for having Sharavati Dam being built, and all of that. As an engineer who is working in that area, he has written that. Okay? And how many of you know that there is a Chamundi temple there in that area? The one Chamundi temple which we know is here in Mysore, right? There is a Chamundi temple established by Maharaja of Mysore with 2 heads in the Chamundi temple there. Okay? Just some history for all of you. Okay? Going back into talking about Vishweshwaraya. Okay? Enough of that. Today's is also a class. I hope you enjoy that. And to say what I need to say about the TiE. TiE is a worldwide organization. Now we are in 14 countries, adding Bhutan as the 15th country. Okay? So we are about 64 chapters now and counting. And we believe in the 5 pillars of TiE. We are all here because of that. One is education, one is networking, one is incubating, one is fundraising, and one is, what else? Mentoring. Right? So that's what we do. With that, I'll let Mahit talk about today's program and let the program start. Thank you so much, Kishan, for reminding me about the Engineers' Day, which is so close to my heart, and about the Teachers' Day. I was a teacher for quite some time and still a teacher. Thank you.
To set the context for today's event, Mahit sir, we have more number of students here in the audience. To all the students who are here, kindly look at this session as an eye-opener, because you might be funded in the nearer days, because quite obvious that there are many organizations who are giving certain funds, and you people are also in line to apply the same. How to make the best beneficial out of it. So the session is all for yours. Now, I request Ms. Aditi Puranik TiE student member from Vidyavardhaka College of Engineering, to introduce the speaker to the audience.
Good evening, everyone. It is truly an honor to stand before you today and introduce someone who has made significant contribution not just in the field of law, but also in the growth and development of various industries and startup ecosystem in India. Mahit Anand is a partner at GameChanger Law Advisors and brings over a decade of comprehensive post-qualification experience to the table. Since joining the firm in 2014, Mahit has played a stellar role in sculpting GameChanger Law Advisor diverse practice areas. With a foundational degree from the School of Law, Christ University, Bengaluru, in 2014, Mahit has dedicated his career to navigating complex corporate transactions. His prolific expertise encompasses a vast array of sectors including technology, education, healthcare, sports, and social impact, positioning him as a versatile legal advisor. He has skillfully facilitated mergers and acquisition as well as venture capital investment transactions for several companies in India. He regularly represents a leading UK-based impact investment fund contributing to the growth of early-stage enterprises in edtech and agri-tech sectors. Beyond his transactional work, Mahit actively contributes to nurturing the startup ecosystem in India. He regularly leads legal workshop and one-on-one sessions at prestigious incubation centers across India. His efforts have culminated in an exclusive partnership between GLA and UNIS School of Business, where he helms legal advisory for all YSB-supported portfolio companies. It's clear that Mahit's influence is far-reaching and his work continues to make a meaningful difference in the life of entrepreneurs, businesses, and industries alike. His expertise, dedication, and passion for both corporate law and social impact truly sets him apart in legal field. With that, I invite you all to join me in giving a warm welcome to Mahit Anand, a leader, a mentor, and a driving force in India's legal and startup landscape. I welcome you, sir.
Quite a large number of attendees this evening, and it's always great to be back in my hometown. I'm from Mysuru as well. Did my school, born, brought up, did my schooling as well in Mysuru. And now that I heard Mahesh and everyone talking about Teachers' Day, the irony in my life is that I used to attend guest lectures and masterclass like this to sort of bump up my attendance. And fast forward my life 10 years later, and here I am delivering with those. But it's the circle of life, what I would call it. But nevertheless, it's an amazing feeling, and been working very closely with the startup ecosystem in Bangalore and in Mysore as well a few years back, where I did a fair amount of work with CII and YI, and with TiE, with the TiE Mysuru chapter as well. And Mahesh has been in fact extremely encouraging, both Mahesh and the other Mahesh as well, so who have been fairly pursuant in terms of trying to build a workshop and a series of masterclass around fundraising and several aspects that which is of concern to startups, and also on the other side, whom they are reliant on are the investors. So the first masterclass that I would be doing today is called the Legal Nuances of Venture Financing and Fundraising. So before I start, I just want to sort of get the feel of the audience as well. How many of you are early stage startups or entrepreneurs here? Excellent. Mahesh is always ever young. So, and then the investor pool would be there. Okay. So the startups, look at the hands raised at this point in time. You probably would be reaching out to them once I sort of finish up my session on how you negotiate your term sheets and your transaction documents. So the agenda for today's session, I've been told that I've given around 50 minutes to an hour to sort of take you through the entire life cycle of a fundraise transaction. How it starts, what's critical in terms of your negotiation, and also and then what's the process involved. More than anything, once your negotiation is done, it just doesn't end there, right? So there starts your due diligence exercise, and then you start building out your transaction documents, and then what we call as closing, and subsequent to which, what are the rights that you're giving to the investors, what's their role in managing the enterprise in which that they have invested in, and two critical aspects. One is the economic side of it, and one is the control side of it. What's the economic side? What are the economic rights that you're giving to your investors? And control in terms of to what extent are you going to exercise your control in the enterprise that you have built. So here's the agenda. First is, of course, I would like to touch upon structuring and negotiating a term sheet, which is step one of your fundraise cycle. Next, once your terms are sorted out, then comes how does the due diligence exercise influence in structuring your transaction. Next is structuring your definitive agreements. And what do I mean by definitive agreements? Are your share subscription agreement, shareholders agreement, a promoter employment agreement, and your restated articles of association. I will get into the exact legal nuances as and when I go through the entire presentation. I do understand there's a fair bit of legal jargon that would be involved in this entire presentation that I'm doing. But bear with me, I'll try to simplify things to you at a level where I'm able to explain what each of these concepts actually mean. If, say, for an entrepreneur, when a term sheet has been shown to you, what exactly do these terms mean is something that I aim to sort of educate you in this workshop. Next comes your closing, post-closing, and action items, and timings and structuring the exit. So at what point in time do the investors want to exit? Why do they want to exit? And what is it that they expect once they exit from your company? So like I was saying, so this is the flow chart. Just pointers for you to take note of. Step one is term sheet or your letter of intent. That's where your negotiation starts with an investor. After that starts your due diligence exercise. Next would be your definitive agreements. That's your, like I just told, the shareholders and share subscription agreement. Closing, post-closing, and investors' relationship with the company. And what I mean by closing and post-closing is essentially those are the action items that are identified as part of the due diligence exercise. And then the exit. So now let's just look at what it is in terms of structuring a term sheet or in terms of negotiating a term sheet. So a term sheet is essentially a document where an investor tells an entrepreneur, hey, listen, these are the terms basis which I would like to make an investment in your company. Review it with your lawyers and get back to me with your thoughts. All right. So here I just like to get a sense in terms of how many of you have gotten a term sheet. Yeah, of course. So what was your first thoughts when you got the term sheet to your hand? What was it that's something that sort of struck you where you felt that, hey, these are the things I need to negotiate with these guys, or these are the things I need to push them back on? See, because a lot of these early stage startups, and in terms of, and let me just tell you, in terms of the kind of instruments are also available today. Probably rewind, say about 10 years back, we had equity pretty much, which played the role in terms of what you're offering your investors. And then, of course, you have your convertible stocks, convertible preference shares, convertible debentures. Now we got convertible notes, right? Now this is a fairly new instrument that's there, and the safe note as well, which pretty much started in the Silicon Valley and it sort of trickled down here to India as well. Now, how do these instruments work, and what is it that even the early stage startups try to seek? So I just want to get an idea, and ideally I'd like to keep this workshop quite interactive with all of you. I just don't want me to be telling you what it is, because we do keep working on term sheets and transaction documents day in and day out, but also I would like to hear from you guys, what is it that sort of strikes your attention or just like strikes your antennas right up there in terms of, okay, this is something that I should be watchful of before I sign on to this term sheet. Okay. So Mahesh, if you could.
Too many pages, too many small things,
Huh.
and deployment,
Okay.
various other aspects which were. I am the founder of the company. What am I doing?
Yeah.
Deployment, and,
The promoter lock-in
yes,
is what you're talking.
period,
Huh.
too many things.
Sir.
Valuation is one.
Of course.
Then there are a lot of jargon like tag along,
Of course.
those kind of stuff.
Yeah.
How the cap table changes.
Yeah.
What other investors who come in, what is in it for me?
Yeah.
Things like that. And many of them, though you say there's an exit, there's a strategy, many of them fight on exit.
Mm.
This is the way you want to exit.
Yeah.
These are some of the nebulous things.
Okay.
One needs to be little concerned and you have to start negotiating.
Agreed.
Exit has to be there. It may not happen in 3 years, it may happen in 5 years or whatever it is.
Yeah.
But many of them I've seen, very big startups, they sit quiet. Some of them, on the other extreme, they go and they put a non-return wall. That means whatever may happen, you will not lose your capital. They give that in term sheets, that is it. That is okay, that makes you comfortable. But otherwise, there are a lot of challenges. By the time you read and understand, as Maheshwar said, when you, at the end of the term sheet, you have forgotten what is in the beginning of the term sheet.
21 pages.
Sorry?
21 pages was the.
I honestly wish I was your lawyer back
To-
then, but
2007,
that's way too much.
2007, when I got my first investor into my company, it was 21 pages, and AMIT legal was the legal.
Acha.
It took me 4 or 5 hours sitting with them, going through. Still, I was not clear. It's
Okay.
too many pages, too many things,
Yeah.
too many subsections, too many. So.
I mean, see, okay, that's good insights. Anybody else has anything to share?
So, yeah, on a very lighter
Hi.
note, it's like when you sign your loan agreement, it's like terms
Yeah.
and conditions
Yeah.
where you don't really go through and you don't understand, but still you
Yeah.
have to, make a decision. So
Great.
It's
Okay.
basically like that.
Fair enough. I mean, valid points. One thing that I think everyone should know, and I think you guys know about it already, is term sheet is not a binding document. It's not the final agreement that you sign with an investor. I'm talking to you with the assumption that you're the entrepreneur, you're running the company. So a couple of things that sort of sticks around when you sign a term sheet is an exclusivity clause and a confidentiality clause. Now, what's an exclusivity clause? Where the investor, he or she is really keen on making that investment in your company, all right? And they say that these terms, whatever terms that we provide in the term sheet, say your promoter lock-in, your tag along, their exits, to what level that they need to get an exit, they say these are not binding. Till we put in the money in your company, these are not binding. But exclusivity will be binding. Now, what do they mean by exclusivity? Saying that you as a company, you will not seek any investment offer from another investor, say for a duration of 2 months from the time the negotiation has started. Now, why do investors come with this particular exclusivity provision and why is it binding? Is simply because they would have spent, now I'm speaking from an investor's point of view, that they would have spent some time, cost, etc. in terms of trying to narrow down on your company, and they're really keen on making that investment. And making an investment, it includes a lot of factors. One, of course, negotiating the term sheet comes with them bringing on their lawyers, which involves a cost component. Along with it, they would have done some level of diligence to try to understand what's the standing of the company, the standing of the promoters. Do they have any background litigation of sorts which we should be wary of? Or is the IP or the product that's been developed by the company, are there any third party claims attached to it? So, which is the reason why typically when you see an term sheet, these are the two clauses typically which are binding, but otherwise none of the terms, the way you said, none of them are binding on the promoter or on the company till they sign the definitive agreements, that your share subscription agreement and your shareholders agreement, and when the investors put in the money into your company. Post which, of course, the contract, you guys, both the promoter and the investors, you guys are contractually bound by whatever terms that you have finally agreed upon. But when the term sheet comes, typically what we see is the startups, they generally get excited. Okay, we've really grabbed the eyeballs of this investor. Clearly, we're going to make, we're going to get a lot of capital infusion into our company, which will help us in taking our product to the next level, higher salary for ourselves, higher salary for our ops team, tech team, marketing, etc. Right? So, but before you pop the confetti and the champagne, there are a lot of things that you really need to, as an entrepreneur, you need to understand before signing up the term sheet. So, like I am saying, like this slide states, term sheets are the earliest indicators of how a relationship may play out. So, it's purely a blueprint basis which a transaction is actually established. It's not something which is definitive in any which way, because this is where you as an entrepreneur, you really need to negotiate the terms pertaining, say, your lock-in. Now, let me just speak from the perspective of an entrepreneur. You really don't want things to be extremely restrictive for you. The thing is, in an investment transaction, the transaction has to be built on a level playing field. You need to understand where the investors are coming from, and you need to understand where the promoters are also coming from. It shouldn't be a situation where the promoters are taken for a ride simply because they are on the lookout for capital. Nor should the investors' sentiment be taken lightly, because they are actually placing a bet on your company at a point in time where you are actually looking for funds. But they do believe in you, and they do believe in your product or your tech, etc., that you are developing. Yes. Sorry, sir. How can it be? Yeah, like exclusivity and confidentiality. No, so how can a court recognize this is, it's purely dependent on, now why would someone take the matter to the court? Okay. Now, I'll tell you why. Now, confidentiality. All right. Now, let me tell you from the perspective of the company. I'm an early stage startup. I've developed a very unique technology, which I've sort of gotten it patented, but I've disclosed it only to you. I've spent all my money, whatever working capital that I have in building this technology, getting it patented, and I have the registration with me. But I don't have more money to push the product into the market, which is why I come to you. Now, you as an investor, if you were to breach the confidentiality obligation that we have signed, now at that point in time, of course, I can tell you that this is a clear breach. Now, that's why confidentiality has been given that level of importance, simply because you are privy to a lot of sensitive information in terms of how I have built my product, which if it's disclosed in the public domain or even to my competitor, it sort of adversely impacts my business. Now, what's the damage that I can claim from you? Now, that's again, see, because breach of confidentiality, be it an investment transaction, be it any form of any contractual transaction for that matter, it's very difficult for me to or for the claimant to ascertain what's the loss that I have suffered. But it is always a valid claim. Now, that's the law. That's the Indian Contract Act, where there are exceptions that are provided, where for a matter of confidentiality, if it's been disclosed, then at that point in time, if the party who is suffering any loss or damage, then at that point in time, they are in their right to claim those damages.
Actually, my question was slightly different. You mentioned about exclusivity of the investor. How can they restrain the promoter to go into somebody else just because they are spending time?
Yeah,
so, same document, it's part of the same document.
Correct.
If the whole document is not binding, how only part of this can be binding, and what recourse will a promoter have if they delay or they don't see the sense of urgency of fund requirement?
Correct.
And it restrains him from going to somebody else. That was my...
Agreed. No, I was just trying to explain a couple of these provisions. One, of course, confidentiality. Now, let's talk about exclusivity, like what you just requested. Now, in terms of how exclusivity works, now the restriction for a promoter not to explore other alternate options is simply because, now look at it from an investor's lens. Okay, now you want to invest in my company, where I have developed a very unique product, say in the health tech space, and you feel that I'm one of the front runners. Now, how do you get that knowledge? it's because you have done your research. You've got a team whom you're paying proper money for them to validate me as an enterprise for you to come and make the investment. You have an investment team backing you. So there's time incurred, there is cost incurred, right? And also at the same point in time, you should also look at it from the perspective of the startup. The startup is also looking out for funds, right? So the thing is, how the entire landscape and the structure of private equity investments are built is such that since the startups are also in that need of capital for them to work, they also appreciate where the investors are coming from. See, because it's just not and the other aspect where they engage lawyers. Even if it's at a level where term sheets are being negotiated, there is cost associated with hiring a legal professional. There is a cost associated hiring a financial advisor who does, even though not the proper valuation, just a fair level of value, even from a technical standpoint. So when these costs are involved, so they drop a exclusivity period saying that, okay, today we are today on September 21st we start talks. You're going to be, this exclusivity binds us for the next, say, 3 months. Generally, that's a ballpark that you can keep for a term sheet negotiation, where they say if things don't go through, we part ways, gentlemen's shake hand, and you are in your right to pursue other investment opportunity, because they don't want to lose out that investment opportunity in that during that period of time, because they really feel there's value where the capital they put in might end up gaining them 2x, 3x, 4x returns at whatever point in time. And also for the startup as well, 2 months to 3 months is a good gestation period where at least they can sort of wait for capital to come with the hope that the capital can come. If not, look at other alternate options. What we do when we are sort of representing a startup or an entrepreneur, we try to limit the exclusivity period, because we don't want the startup to be the negotiation to prolong for a longer duration, because if they are able to find options, reduce the exclusivity period. If I am on the investor side, of course, it flips, right? I mean, so the thing is, I've sat on both sides of the table where I've represented investors, I've represented startups. So I understand where exactly things, yes.
Yeah, I think the key there is that we don't want the investor to go around shopping with the term sheet in hand.
Both ways,
Exactly.
both ways. Even for the startup, so no, see, I'll tell you, that's a good point that you made, Mahesh, where the investor will come, they will say that, okay, fine, I'm going to value your company at 5 crores, and I'm going to invest it at the 5 crore valuation. Now, me as a startup, if I really want to be this sly guy, I probably will take that 5 crore valuation and I can bump it up. And I can take it to the other investor. Hey, you know what? My company is actually valued at 5 crores. Or I can even say it's 7 crores. That's not stopping me from doing it. But you actually have made sure that you got the exact valuation of my company. So that's how things work. So that's exactly how the exclusivity things work.
But what has been your experience?
No, I mean, see, honestly, there's very little litigation, to be honest. See, because startups don't really go ahead and sue investors saying that they breached their exclusivity, nor do the investors do that, except for matters of breach of confidentiality. No, exclusivity, to be honest, it's something that if it were to come up, practically speaking, and the way I've seen things, how it play out, there'll be a red herring of sorts, and the investor will be like, why did you do it? I mean, the knee-jerk reaction or the honest answer of a startup would be, boss, I really need money. I mean, that's about it. I mean, if they say that this was a clear violation, fair enough if you want to take it to the courts, but to what extent do you want to fight it out? Because litigation in itself is a fairly expensive affair in India. And what's the claim that you are looking at? You probably want to, and generally what happens now, if an investor were to make a claim, the cost that they would want the startup to reimburse them, the legal and financial costs that they have incurred in terms of trying to formulate a business plan and invest in these guys. Nothing beyond that. It's not a multi-million dollar sort of a dispute settlement, but it's the amounts that these guys try to end up spending in terms of settling, in terms of looking at investing in those companies.
Latest example was Twitter buyout by...
Exactly. That's exactly what it was.
Even though it was not a completely written document, but they got stuck with it.
Yeah. I mean, if you were to look at the finer print when things goes into the documentation stage as well, I mean, I really can't come up with a better example than Byju's, to be honest. To the level at which investors rode the high waves and also came crashing down when the valuation sort of dropped, what, 99%? Yeah. So it works both ways, but yeah. So some of the key deal terms that one needs to look out for in a term sheet is equity ownership. So that's essentially for the investment that the investor is making. What's the equity that you're giving them? The valuation. Now, bit of legal jargon here. Under the Companies Act, if a private limited company is looking at raising funds, they are required to obtain a valuation certificate from a registered valuer. Now, that's the law. Okay. Next is governance. Now, once the investor makes an investment in your company, what's the governance structure? Typically, investors ask for a board seat. Now, this board seat is a non-executive board seat. That means that they won't be part of all the decision making here in the company, but at the same point in time, there's something known as an affirmative vote matter, which is there in typically captured in a shareholders agreement. What that essentially states is, now say for example, today your company is valued at 1 crore, okay? And I'm the investor, I make an investment of say around 30 lakhs. So that's roughly that's exactly 30% of what the company's valuation is. And of course, I will be in my right to come and ask you, boss, I have put in so much money in your company. I should have the decision making power, say in terms of if you want to pivot your business. Now, say you're working in a particular sector, health tech, directed towards, say, blood cancer. Now, from blood cancer, you want to pivot to, say, breast cancer, any other form of cancer. Now, for you to pivot from blood to breast cancer, do you need my approval? That's exactly where the investors come and ask. I put in that money, so if you're going to pivot your business, it should have my approval. So that's how investors sort of, negotiate their rights. But again, it's dependent on, and this is exactly where it's very important for startups also to recognize and understand, that the bargaining power is just not in favor of the investor. It flows both ways. It depends on how much that person is investing, what's the value that the investor is bringing to the table, and do you think the investor is worthy of giving them XYZ rights. There are plenty of rights, like you were rightly saying, tag along, drag along, and right of first refusal. There are plenty of these rights which I'm going to take you through in my presentation, what I call as economic rights there. And in terms of what's the restrictions that also be imposed on the promoter. Yes, sir. Yes, please. Yes.
On the valuation, even though under the Companies Act, the valuation report is required.
Yeah.
The valuation standards, as I am aware today, they are not comprehensive enough to do a valuation of a startup because there is so many things are nebulous. For example, either proof of concept is in the one stage, whereas AICPA has a standard which covers right from proof of concept, prototype development, and things like that.
Correct.
How do you deal with such kind of, because the valuations are, they look very hypothetical sometimes.
Correct.
You know? Some people justify saying it is not a science, it is an art. But then if you expect a high pre-money value now, at the exit it has to be multiple of that.
Yeah.
So that is going to be a challenge.
Yeah.
So, of course, DCF will show whether that kind of cash flow is there for them to buy back, or can you get another secondary investor to give them exit option. So what has been your most challenging thing?
See, more than challenge, it's, what I would say is, it's a fantastic point that you brought up. A lot of these startups typically, they just say yes to an investor when they come up with a very solid valuation saying that it's just started, all right? They probably would have acquired 3 or 4 customers, but at times investors, what they do is, and generally, now let me just play it out practically for you, okay? Most of these investors, if you look at VC funds, how do these funds operate? They have LPs, and LPs put in the money in these VC funds, where the VC funds are actually obligated to deploy this fund within a particular point in time. If that doesn't happen, now VCs are also very eager to push that money by end of March 31st, whichever year they want to push out that money. Now what they do is, now if they find a startup where they feel, okay, this concept is pretty good, this idea is pretty good, the product is pretty good, why shouldn't I put in the money there? What they do is, they come up with a valuation which at times probably would not even make sense to the level at which the startup is operating. But on the flip side, if you look at the startup is also very eager to receive funds. Now the mistake that happens there at that point in time is that they raise money at a very high valuation. Now what happens for subsequent investments? Because what happens is, at a later point in time, say 2-3 years down the line, if they are not able to achieve the revenues at which their startup or their enterprise was actually valued at, then, and if they want funds, what happens at that point in time? Then it's called a down round, where they're issuing shares lesser than what they had issued shares in the first place. And then the anti-dilution kicks in, wherein the first investor who has put in the money, and if they have really pushed hard, there's something known as a full ratchet anti-dilution. So that means today, if I issue shares in my company to you at 10 rupees, and tomorrow, say 3 years down the line, if I issue shares to this gentleman at 5 rupees, then you have that right where additional shares will be given to you at 5 rupees, so that you maintain your shareholding, which sort of dilutes me as a promoter, my own shareholding in the company and the valuation of the company. So it is that's pretty much, that's the reason why the whole concept of valuation was introduced under the Companies Act. Because prior to this, prior to the 2013 legislation, the 1956 Act didn't have this requirement. And now it is to be done by a registered, accountant who has experience for about 10 years, and then also a merchant banker. Now, India is of course receiving a fair amount of FDI as well. Now, under the FEMA as well, you are required to obtain these valuation reports. So it has become very critical, but then again, we being very savvy with trying to find loopholes in the system, there is something known as a rights issue process. What most of the companies try to do is, if you are raising money from an existing investor, you really don't have to go through the valuation process. So what do some of the promoters do? They just transfer like 2 shares to you at face value. So you're not paying that level of investment for you to become a shareholder in my company. It's 1,000 rupees a share, I transfer 2 shares to you, you pay 2,000 to me, you become a shareholder. Now, now I want to raise further capital. Now you have already become a shareholder in my company. If I have to raise money from you where you are already a shareholder, I don't have to do the valuation. So this is the loophole which they have figured out. But MCA sort of actually clamped down on companies on this regard, because they have tried, because even MCA has also figured out, okay, this is the loophole that they tried to figure. Strangely, I haven't seen an amendment come to that effect where they have tried to sort of circumvent this issue, but we have seen this happen. A lot of these companies, where if they want to say raise a token size of 15-20 lakhs, and they don't want, because if you have to get a valuation report, you will end up coughing up around 4 to 5 lakhs, which is almost like 1/4 of the investment money that you're getting. You wouldn't want to do that. Might as well just do it within 2,000 rupees and just get things sorted out. So to answer your question, valuation is very much needed. I mean, in reality, like you said, a lot of them, they sort of bump up the valuation so that investors are ready. Exactly. Now that's what happens. The after effects of it, nobody knows. See, because sometimes startups also take a punt, thinking that, okay, it's working at this valuation, we might grow, or they probably would be carried away by what the investors have to say. But if things don't work out, then it's quite disastrous for them. So yeah. Step 2 is due diligence. Again, due diligence, I'm guessing both Mahesh and you are fairly aware of what a due diligence exercise entails, and it's quite an exhaustive process. So a due diligence exercise, for everyone's knowledge, is something that's conducted by an investor. Before they put in money into your company, they will make sure that they look at the entire organization setup, both from a commercial standpoint and from an organizational standpoint, for them to know that, okay, this is a viable company for us to make an investment in. Now, why do they do that? Now, see, there are several sectors that they look into it, items that they look into it. Corporate and regulatory, intellectual property, labor, your commercial contracts. And what I mean by commercial contracts is how much revenue you are generating through your customers, customer agreements, and what your customer acquisition plans are, and how much money is going out from the company to your vendors, to your suppliers, to your service providers. Lastly, to see if there's any pending litigation or there's any claims against the company. The reason why they do it is they want to make sure that if they are putting money in your company, they don't want that money to be spent in sort of fighting your legal battles or trying to cover up your non-compliances. So, which is why a legal due diligence exercise is conducted, just so that they know that this company, the creditworthiness, like how before you take a loan, your credit score is sort of evaluated, is pretty much similar to how a due diligence exercise is. So, these are some of the things that are looked into at the time of conducting a due diligence exercise. Corporate information, your commercial contracts, ownership of IP, what's the capital structure, how many shareholders do you have at this point in time, real estate, environment. Environment is because if you are working in the climate and sustainability space, environment compliances are very critical. Labor law, corporate law compliance, loans and indebtedness, and litigation. So, once the entire process of legal due diligence is completed, and if the investors are satisfied that, okay, this is a fairly good company, see, because honestly there is no company which has zero issues unless it's a company that is freshly incorporated, which has very few employees, and they've just begun their operations. So, apart from that, at every point in time, when you conduct a legal due diligence exercise, and every time some issues are being unearthed, how investors try to work things out. See, just because I found an issue in your company or a non-compliance in your company, that does not sort of raise a red flag in me as an investor to say that I'm not going to put my money in this company. How best can I work with this company in sort of making sure that this particular non-compliance is handled by the company, but at the same point in time, I really want to put my money in this company because I see value in the product or tech that they have developed. Now, couple of things that sort of you see in a transaction document. One is something it's called as a representation and warranty. Now, what's a representation and warranty? In common language, representation and warranty is pretty much a promise that I'm making to you, saying that, hey, listen, I'm a company incorporated in Mysore. I'm fairly compliant with applicable labor laws, applicable company law, or if I'm an LLP, I'm compliant under the LLP Act. And also my customer contracts that I have signed and that I have showcased to you are valid. These are the revenues that I'm earning. Now, why is it important from an investment transaction? These are called fundamental representations and warranties. That is because it's very fundamental to my business, and it's very fundamental to an investor as well, for them to believe in what I'm trying to tell them, that this is what my business, and basis which they are making the investment in my enterprise, right? So, it's basis these reps and warranties, which will be covered in your share subscription agreement, the investment would be made. And what happens if I am in breach of it? If I am in breach of it, the provision called indemnification, which you would have seen, comes into play. Now, what is indemnification? I'm not going to give you the definition of indemnification under the Contracts Act, but I'm going to tell you what the term indemnification means. Indemnification essentially means making good the loss that you have suffered. That's all it is. Now, you put the money in my company, if I were to use the investment money that you have put in my company to pay out fines or to pay out any regulator, then it's a loss that's incurred to you, because out of, say for example, out of 30 lakhs that you have invested, if I use 10 lakhs to pay out my fines for non-compliance, there's a business plan that we would have agreed, where you would have said, my 30 lakhs, you need to invest it here, 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 and this is how you are supposed to develop your product. Now, if I end up using 10 lakhs of that amount in paying out fines, that's a clear breach on me. Now, what happens at that point in time is where I'll be liable to indemnify you. And by indemnify, what I mean is where I'll have to make sure that the 10 lakhs that you have invested, either I pay you back or either I use it in a manner that was principally agreed between you and us, right? So, that's representation and warranties, then that's indemnity, and subsequently what happens is, once you understand what those reps and warranties are and the indemnities are, those are the things which goes into your transaction documents. So, typically in an investment transaction, there are two agreements. One is a share subscription agreement, the other is a shareholders agreement. Basically what it means is, a share subscription agreement is an agreement where it records the terms basis which shares have been subscribed by the investor. They pay X amount, Y a number of shares are being allotted to them. What are the representations and warranties the promoters make? What are the indemnities that's been given to them? That's about it. Now, what's there in the, under the SSA, what's covered is type of securities. Is it equity? Is it CCD? Is it CCPS? Is it a convertible note? Type of security would be mentioned. The investment amount and closing date. And just to clarify for those who are in their very early stages of looking at fundraise, there's a distinction between an execution date and a closing date. So, please be mindful of that. So, don't think that the day you sign the agreement, money hits your bank account. It's only when actually money is being remitted by the investor is when money hits your bank account. So, that's called closing. So, so just because you sign the agreement doesn't mean that tomorrow money is going to be in your account. There are a lot of actions like what you call as conditions precedent. Now, what are these? Actually, I wanted to touch upon these two items which I missed. Now, there are two things called conditions precedent and conditions subsequent. Conditions precedent to closing and conditions subsequent to closing. Now, what are CPs and CS? Now, generally what happens after a due diligence exercise is conducted, if investors are to identify high risk action items or high risk non-compliances from the company. For example, based on my experience, I am going to tell this to you. Now, say if company X has about 40 employees and they have had 40 employees for the last 6 years, but they haven't made deductions for PF or ESI. Now, that's a massive red flag, because the repercussions, the fines, the penalties, it's very high. Now, that's a high risk action item. Now, as an investor, what I tell the company is, listen, go to the ESI and the EPF office, pay up whatever the fines it is for the default that you have committed. Only once you do that, sort it out, rectify it, and you get an acknowledgement from the concerned regulatory body is when I will make the investment. So, that's what you call as a condition precedent to closing. Now, similar to this, there are bunch of other non-compliance. Now, say if the company has raised funds earlier. Now, after they have raised, there is something known as a return of allotment called a form PAS 3, which the company is required to file with the Ministry of Corporate Affairs after 15 days of receipt of funds. If they don't do it, and if it's not a startup, if it's not a small company as defined under the Companies Act, then the quantum of penalty is the lower of 2 crore rupees or the amount of investment that they have received, which is significantly high. Now, what will I say? As an investor, I will tell them, please sort this mess out, then I am going to put the money, because I don't want my money to be going out to paying out these penalties or for non-compliances. Similarly, there is something known as a condition subsequent to closing. Now, what is the condition subsequent to closing? Now, these are action items which do not pose a significant risk to the company. Now, say the company has engaged web developers or guys who develop their app, all right. They have signed agreements with them. Say for example, they have signed their IP assignment agreement and whatnot, but they haven't gotten it stamped. Now, if I am a lawyer, I'll tell them, and in the interest of a transaction, I'll tell them, okay, if it's not stamped, it's fine, sign up the agreement, but make sure that they pay the stamp duty after you sign the agreement, because you don't want them to hold off on their transaction just because they haven't got the document stamped, because the risk is very minimal. In Karnataka, as per the Karnataka Stamp Act, generally a services transaction or an agreement, the stamp duty payable is 500 rupees. And if you haven't gotten it stamped, the penalty is payable up to 10 times, which is up 5,000. So it need not be 5,000, it's up to 5,000. It can be 800, it can be 1,000. But the amount is very small and the risk isn't that significant. So which is how you classify some things as conditions precedent to closing and conditions subsequent to closing. All right. So those are the ones: CPs, closing action items, and CS, indemnities and specific indemnities, and limitation on liability. Now limitation on liability is something I think for startups or for promoters is something that you should be mindful of, is in terms of how you cap your liability with the investors. You don't want to give them anything and everything because for whatever be the reason where there has been a breach or violation of the transaction document. From an entrepreneur standpoint, you should also make sure that your liability is limited, and also you should ideally have a level of flexibility in terms of running your business. So which is why if you see in some of these investment transactions, there is something known as a de minimis clause. Now what is a de minimis clause? A de minimis clause means that if a claim is made amounting to say 50 lakh rupees, 50 lakh is called as a de minimis value. So till a claim of 50 lakh rupees has been made against the company or the promoters, the investors won't come and bother you. They'll tell, okay, you might have goofed up somewhere, make sure that you sort it out. We won't come and ask for money from you. It's not 50 lakhs, generally it kept at around 10 to 15 lakhs, but just for illustration purposes I am telling you. It's generally the de minimis clause for early stage investments, it's kept anywhere in the range of 8 to 12 lakhs. So till about 8 to 12 lakhs, the investor says, I am not going to come and bother you, you sort it out yourself. But if it crosses 12 lakhs and if our money is being put on the line, then you will have to make good the loss that we have suffered. So that's the protection that the promoters can sort of negotiate in the transaction document, where they'll say that if anything were to happen, I need this sort of flexibility, where if a non-compliant, I don't want you guys to be coming and bothering me for the smallest of non-compliance or a breach that I might commit with a customer or a vendor or a supplier or a service provider. But that's the flexibility that they require. Another thing to keep in mind, which I always advise promoters to have it in transaction documents, is that make sure that none of your personal assets are attached to an indemnity claim. Don't ever allow. If it's not there in the document, make sure you add it and don't budge back on it. So these are some of the things where how you look at capping your liability under these transaction documents, because generally for startups or entrepreneurs, when you get a document from an investor, trust me, it's going to be skewed in their favor. It's for you to work it out, for you to review it, and for you to negotiate what works for you, what doesn't work for you. And even before that happens, the term sheet, what I just explained, is pretty much is like a blueprint. So make sure that you get your term sheet right. Once you get your term sheet right, then you are pretty much, I wouldn't say 50, at least 40% in the game, where you know, okay, this is what I'm going to get, this is what I'm going to give. And generally what happens is, when a transaction document, either if it's drafted from an investor council, there would be certain deviation in the terms, not by a great margin, but you will see certain deviations. Say for example, what I would say is something known as like a promoter lock-in or vesting of promoter shares. Now, when an investor invests in a company, they do not invest only in the company, they invest in the promoter, because there is credibility attached to the promoter, there is value that the promoter brings. So which is why they say that the promoter shares will be locked in with this company for 3 years, and 4 years, and the vesting happens 25%, 25%, 25% year on year. So after 4 years, 100% of the shares get vested with the promoter. Now, are you okay with having this sort of lock-in without having any leeway for liquidity? Now, what you can do is, as a promoter, you need to negotiate for it. to say that, okay, listen, I'm okay with the lock-in because I understand the principle and the basis which you are making this investment. But at the same point in time, at least anywhere between 5 to 7% or 7 to 10% of these shares should be freely available for me to transfer, so that there is liquidity available for me to move my shares either to my kith and kin or to any third party that I may deem to be appropriate. But of course, the exception being, I will not transfer it to a competitor, and which you as a promoter also will tell the investor that, boss, you will not transfer your shares to a competitor unless I don't give you an exit within whatever duration that we have agreed to. So if the investor says, or if the terms that are agreed that within 5 years that you will be getting an exit either through an IPO, strategic sale, any of these, if nothing works, then the last course of action for an investor is something known as a drag along right, where the investor will say that I am dragging you, that's the promoters, and all the shareholders, where I am going to sell it to a third party whom I have identified, who is going to give me the return that I have expected, even if not 5x what I have expected, I am going to get 3x. So you better sell your shares along with me, and that's how the entire company gets sold out. So that's what we call as a drag along right. Any questions? I think I've been talking quite a bit.
And I'm wondering why some of the startup founders are not asking questions, because this may be quite esoteric to most of them. So I don't know whether we should have
any questions?
I should have a workshop.
I'd ideally like to keep this interactive, so yeah, go ahead.
I know, miss. I think you started. That's the thing I was about to ask. I was about to ask.
Which one? Oh, you, okay. Yes.
In terms of due diligence,
Yeah.
like as a startup, we don't actually maintain 100%, the account. Let's say, for example, at least in my case, I will be so hyper. I want something, really good that I need to go quickly buy and do an experiment. So, but the vendor says, okay, transfer the money now, or pay it on a Google Pay, something like that, and I will immediately send the money from my Google Pay, because adding their account and transferring it might take some time, or it's all accounting process, right? But there's so many occasions where I have paid a lot of things from my personal account, and which is not actually part of the company accounting process or the contribution. Like that, there are so many vendors who doesn't want to give us the bill, but we still need that product, to kind of carry on with our R&D structure. So those things we really can't account. I mean, it's not just my case, probably a lot of other cases, right? Plus a lot of travel expenses, a lot of things which we can't really manage or maintain, because it's a very lean team, and we really want to kind of go be aggressive in terms of growing. So what's your suggestion? Is it okay for an investor,
See,
at the early stage?
The question is not about is the investor okay. What really matters is how much money are you expending and towards your vendors and service providers, and at the same point in time, how critical it is for the services that you are availing. Is it extremely critical for your business?
It's about the timings. Like I can't wait for 5 days, to
see,
get
that's
the
the thing.
process
See,
done.
the thing is, investors aren't these, I'll tell you this, they aren't these nitpicky people who look like every smallest transaction that sort of is in related to the company, be it your customer side where you are earning revenue, or be it from your vendors or service provider side where you are expending money. Generally, how diligence works is, now if I am conducting the diligence on you, the way I look at your books of accounts, and in terms of the way I look at your contracts, is I look at from a revenue generating standpoint, I look at around top 5 to top 10 customers of yours. I'll see if you got proper agreements. If you got 50 customers, I really don't care about the rest of the 40, but I look at the top 10 who are primarily generating revenue. And from an expense standpoint, I look at the top 5 to 10 vendors or service providers from whom you are availing services, and also at the same point in time, which is more critical to your business. That's it. You can have 100 other vendors to whom you can pay through your personal account or whatever it is. See, the thing is that the point of a diligence exercise is to make, see, the result of a diligence exercise is not pinpoint accurate. Be it with any enterprise for that matter, it is just not pinpoint accurate. It's a general overview where you get to know, okay, this is how things work. Now, I'm telling this top 5 and top 10 for an early stage startup. For a much more mature company, you probably would look at more. And generally, when it comes to startups, if you are a 5-year-old company, the diligence that's been conducted is typically for the period of 5 years or for a period of 3 years, for the last 3 years. They do, if you are a startup, if you still have around 10, 15 employees, but you are in the stage of growing, even if it's 10 years, they look at 3 to 4 years of diligence. They don't look at the entire 10-year track record. So there are a lot of things that goes into consideration, and it's not something where an exact science where just because you paid out few vendors because you really needed to get those services or those products, it's not something, not all transactions are being reviewed. That's my answer to you.
Thank you.
Yeah. Yeah, Mahesh.
One of the points which I just want to make is that they look for a pattern. If you see a pattern where there is some amount of money which is being spent without any accountability in the book of accounts, that means that there is a possibility of pilferage.
Correct.
So they usually look for that and try to say, hey, where is the account for this?
Yeah. If it's going through the company's account, of
Exactly.
course. Of course. But he's been quite a generous promoter who's paying out from his own pockets.
Yeah.
No.
In either of the two cases, if there is no purchase order, there is no invoice.
Exactly.
And in the other cases, you're doing some, and then you're claiming it back without proper receipts.
Exactly.
So these are all, the case of Byju's comes into picture again, right? I mean, and Satyam.
Satyam as well.
Yes.
Satyam as well.
So.
Like
Mahit,
sorry.
Here, one more question. So exactly adding to his, note. Nowadays, what we see is promoters, they put in money, just that, probably they would have signed a contract with an investor, and probably investor might be taking some time to invest in his companies. But for him, he has to run a day business.
The promoter.
Right, as a promoter. But to overcome those lag from the investor, he starts getting money from his personal capacity he put into the company. But end of the day, what happens is even he does not limit himself. For him, he has to run the business, so he does not limit himself to put in money. So he goes around and gets money and gets invested in a company. But as an investor, finally when he comes back and sees that, okay, a lot of money has come in from a promoter, but still he is looking for money from an investor. So how do you look at this pattern, like promoter getting money from his personal capacity and expecting an investment from an investor as well?
Realistically speaking, if this promoter is actually able to draw funds where an investor is still sitting on the sidelines, then the investor really needs to evaluate why they aren't putting the money. Because if the promoter is able to garner that many funds where investor X is still sitting on the sidelines and thinking, should I invest or not invest, there is a value proposition attached to it. Okay. But that being said, that goes back to the first point which we were discussing on exclusivity, right? So if you have signed up with me on a term sheet where you said that I'm going to make the investment in your company, but the exclusivity lies for 2 months, I can't go to another investor, knock on their doors and ask for money. So for the 2 months, I'm going to sit across the table with you and we'll negotiate our deal terms. If it falls through, it falls through. Then I go to the market and I seek investments. Now, what I'm still trying to understand the concern that you are trying to address.
If I want to articulate it better, so what happens is, for a startup there are 2 investors, I would say. So there is an agreement between 2 investors that you put in some money, I will put in. So I would say probably 5 crores is the the expected investment. So what happens? There are 2 investors. One investor, there are tranches.
2.5 each.
Tranches happens. So what happens is, one investor invests diligently, but another investor takes time. But as a promoter, he cannot go knock door on the other promoter, investor asking for money. Rather, he will just find his ways to get in that money, thinking that the other investor will come and invest.
See, that's purely circumstantial. It's not one for me to tell you what's right or what's wrong, because if a startup needs that money, they will go out looking for that sort of funds. Of course, respecting the terms that are there in the term sheet is also very sacrosanct for them, both from an investee company standpoint and from an investor's standpoint as well. But if one of the investor were to back out, they are still free to go raise funds from whoever it is. It doesn't mean that because they signed the term sheet that that particular investor is the only person from whom that they are required to raise funds. If they're, like you just gave the example or illustration, if there are two investors who are coming in ready to put 5 CR into the company, split 2.5, they can still raise money from that particular investor who wants to put in the money. If the other one were to back out, respect the exclusivity period, and once it's done, look at raising funds from elsewhere. Or also, that's the point where the the investee company will have a fairly stronger hand in telling the investor, saying that you and person X, both of you came together, both of you agreed to put in 2.5 CR into my company. The other person has done it, you haven't done it, for whatever be the reason. So I would like to limit my exclusivity period. Say if I agreed for 2 months, I would like to bring it down to 1 month. Now, how would that happen? One, you might argue saying that it was signed in the term sheet, but this guy this guy backed out. I really don't want to leave this exclusivity period sort of lag on for another 2 or 3 months. It's something that is definitely workable. See, the thing is about law and about agreements, what everyone think is agreements, of course, where they think that it's cast in stone. So once it's there on fine print, I really can't do anything about it. But it all boils down to how well you can negotiate even after a particular point in time. There's something known as an addendum, there's something called as an amendment. You can always execute an amendment or an addendum to your agreement where you can certainly modify the terms. But it all just boils down to how well you can negotiate the terms. See, because the thing is, let me just explain this to you from a very practical standpoint. Not every breach or violation is taken to the court of law, because litigation in India is one, time intensive, and cost wise it's very expensive. So for every small breach or violation, matters aren't really taken to the courts. It's generally, sorry?
It is not time bound.
Sorry?
Litigation is not time bound.
No, it's not time bound. That's what I'm saying. It's just time intensive is what I'm saying. So it just, you never know when it happens. And you have NCLTs, tribunals that are set up. But most of the time, what happens generally in any such disputes, most of the time it's out of court settlements. So that's what, that's the faster way of working things around. And how dispute resolution clauses have also sort of evolved in transaction documents is that they look at arbitration. Why arbitration? Because it's a more faster way of resolving disputes. Two, also because you have subject matter experts. Slightly expensive process compared to taking the matters to a civil court. But the thing is, you should be mindful in terms of how you structure your arbitration clause. Because in India at this point in time, arbitration, to appoint a particular arbitrator, the costs associated with it is significantly high. Now what we also as lawyers advise our clients is, I don't know if you have, any of you have seen this in commercial contracts or even in your investment agreements, how generally arbitration clause is structured is that, say you are the investor, I am the investee company. The arbitration clause earlier, the way it used to be structured is, you will appoint one arbitrator, I will appoint one arbitrator. So the two arbitrators that we both appoint, they will jointly appoint another arbitrator. So there are 3 arbitrators who will be looking into the dispute. The cost for one arbitrator is exorbitantly high. Multiply it into 3. So now what we advise our clients is, look for a sole arbitrator, jointly appoint, because it can't be skewed towards the investor saying that I'll appoint an arbitrator, he will decide the case. Company will not agree, because they know that, okay, this fellow might cast the judgment in favor of the investor. Now, the same thing goes to the investing company as well. So, which is why they jointly appoint one arbitrator, and that's the thumb rule that we follow. Cross-border transactions are different. Why? Because if you are looking at Indian investee companies, most of the investors who are coming in from the US, they will say laws are governed by state of California, and if any dispute were to arise, courts of California will have exclusive jurisdiction. So, if the founder in India, if there is a claim, he has to fly all the way to California for a hearing, which makes absolutely no sense. So, how do you work around these cross-border dispute resolution clauses? Typically for Indian clients, what we suggest is something known as SIAC, that is Singapore International Arbitration Council. So, what we do is we draw a neutral jurisdiction, that the case would be determined by the arbitrators appointed by SIAC. Then we will also generally, since it is a company incorporated in India, operations are happening in India, investment is made in India, what we push back on or what we recommend is, let this agreement be governed by laws of India, because there is nothing in the US, nothing of US law applies to the operation of an Indian company. Why are we governing this agreement based on US law? Let it be based on Indian law, but we call the guys from US to Singapore to settle a claim. Works out cheaper for Indian founders as well. They might not agree, at times we look at London. It all depends on where the promoter likes to go on a vacation along with settling their dispute, but yeah. But here, these are some of the instruments that are generally issued by companies in India. Equity, pretty straightforward. You give the money, you get shares in the company, which is what you call as equity. There is voting rights attached to your equity shares, but the downside of equity shares is that they rank the last at the time of a liquidation event. You have CCPS, CCD and convertible note. CCPS and CCD are all convertible instruments. The difference between CCPS and CCD is that debenture is essentially considered as a debt. CCPS is a convertible preference share, which gets converted to equity. Now, if you look at the hierarchy in terms of what ranks first, should a company get acquired or should the company get wound up, first comes your debt. So, if you have taken any loan from the bank comes first. If I have taken equity, bank ranks there, I rank here. Then above me comes CCPS holders. Then you have the convertible note and CCD holders as well. Now, this is a very new instrument. Have any one of you heard of what a convertible note is? Yeah? Okay. So, it's pretty alien, but it's sort of picking up traction in the Indian startup ecosystem. So, there's something known as convertible note. So, essentially what's a convertible note? It's a hybrid of a debt and equity. How does convertible note work? Now, you have raised funds, right? So, you invest money, you get equity. That's it, right? I mean, that's how things work. That's how investment transactions work. How does convertible note work? You invest money today, you won't get equity today. You will get equity at a later point in time. Now, what's the term and how and when do you get equity? Is contractually agreed. Now, what do I mean by contractually agreed? Now, say if I am investing money in your company and I want to subscribe to convertible note, okay? So, what I do is I invest 1 crore in your company. This is at a point where the company has zero valuation. There's no valuation at all, but I believe in the product and I believe in the promoters. I put 1 crore. And then we contractually agree that when the company hits a 5 crore valuation, you will be required to give me equity. Now, convertible note is pretty much like how you take a loan from a bank to purchase a car or a home or whatever it is. There's an interest component attached to it. So, today for 1 crore, you give me 100 shares. Now, after 5 years, if you're going to, if and when you hit that 5 crore valuation, there's an interest attached to it and I end up getting 115 shares. So, that's how it is. So, at that point in time for 1 crore, I was entitled to receive 100 shares, but interest has accrued, 115 shares get accrued to me at whatever point in time. Now, that's how a convertible note, that instrument works, and this is something which most startups in India are using. Why? The reason being, there is no valuation requirement. So, there is absolutely no valuation requirement for a convertible note. So today, if I've just started incorporated my company, and if you would like to invest in my company, I can issue convertible notes to you. There are certain criteria. One, of course, I should be a startup registered under the DPIIT as well. And if I'm that, and if you have, and if you are willing to make the investment, I can issue convertible notes to you, and we can contractually agree that once I hit a 5 crore valuation, you will be getting X number of shares. Now, how does that work? Now, say for example, 1 crore you have invested. Okay. After we hit 5 crores, those notes gets converted to equity. Now look at the investment, 1 crore to 5 crores. What's your equity holding? It's 20%. Now, that's how much you're entitled to receive. But the upside for an investor here is that you made the investment in my company when it was just an idea. I had no revenues, nothing, but you took a punt. So, how these note agreements are structured is that you are just not entitled to that 20%, but there's an added amount to it. Now, how does that added equity comes to you? The terms that are being discussed at that point in time is you will be given equity at a discount of 20%. So, what do I mean by a discount of 20%? If the company is valued at 5 crores, the shares that would be allotted to you will be calculated at a discount of 20%. That means at a 4 crore valuation. That means you will end up earning 25% instead of a 20% equity in my company. The 5% is the additional equity that will be allotted to you simply because you believed in the company and you invested it at whatever point in time. So, that's the upside that the investors get to make. So this is the fairly new instrument which we've been seeing a lot of early stage startups who are actually allotting these shares, and investors are also fairly comfortable in subscribing to it. One of the condition is that it has to be converted to equity shares within 10 years from the date of issuance. It can't be beyond 10 years.
So the year-end balance sheet, where will we see it?
No, so it will be called as a debt. It's a debt. It's a debt. That's all. It's plain and simple debt instrument. That's all. Yeah. No, for a convertible note, interest is made applicable. It's generally in the range of like how around 7 to 8%, 6 to 8% is what the interest would be calculated.
It's payable by end of the year.
No, what I'm saying is it's not payable. See, convertible notes gets converted to equity. So today, you put that money in my company. Me as a promoter or me as the person who's running the company, I won't be giving you shares. I'll be giving you a convertible note. So that means after a particular point in time, you are entitled to hold certain equity in the company. And the thing is, for 1 crore, you are entitled to have, say, about 100 equity shares. But since the interest component gets attached to it, after whatever that maturity period that we have agreed upon, you won't just get 100 shares, you will probably get 115 shares. Now, that's the interest that gets added. So, it's not monetary, it's calculated in terms of the number of shares that will get allotted to you. Yeah, interest is accrued. So, like I told you, it's pretty much like a loan transaction. So, there is interest attached to it, and that sort of gets accrued to you in the form of equity. CCD, again, see, there are two types. Optionally convertible, compulsorily convertible. At what point in time, what's the call option? These are purely contractual terms. CCD also is a debt instrument. But the thing about the convertible note here is that you have certain, there are certain regulatory terms and conditions attached to it in terms of who can issue it, because CCD can be issued by any private limited company. It need not be a startup registered under a DPIIT, but a convertible note has to be. So, there are a few regulatory distinctions in that context.
Share warrants are
Not too many, sir. Not too many. It's pretty much preference shares is what they look at. Early stage startups, convertible notes is what I've been seeing of late, that it's a more preferred form of instrument. But a more mature investment transaction involves CCPS. It is that and equity, because you have preference, there are terms and conditions that are laid down for your preference shares to get converted to equity. and also at the same point in time they rank higher than your equity shares. And if it's an investment raised by a fairly mature company, you really don't have that many kinds of securities that have been issued. It's either equity or CCPS. So of course you would want to be the ones who are ranked on the top. So CCPS is the way to go for it. Which one? So that is the thing is 20 years it's not under law, but generally 20 years they leave it because there are other exit options. You look at IPOs. See, it's a lot of these transaction documents that I see where they say startups, fairly early stage start, they say the exit will be given in 5 years. What are the forms of exit? The first one would be IPO. Do you really think that the startup would achieve an IPO? Maybe not. I mean, 80 to 90% of the time they don't. But 20 years is what they give as an outer limit. Sorry.
So let's say a startup startup investor gets his equity over the period of time through convertible notes. Is it long-term capital gain or short-term?
Sorry, come again. A startup founder.
Startup investor.
Okay.
Takes an exit over the period of time, and is it like a short-term capital gain or long-term capital?
Long-term, of course, because with the new budget, they've sort of had made it very uniform for any and all forms of securities. Anything that goes beyond 2 years, it's long-term capital gains. So that's how it would be calculated. Okay, I think let me just. Sorry. No. See, there's no buyback option. The reason being, you're not given any. See, the security is just a convertible note. The company wouldn't buy back unless there is a situation where if the company is winding up. At that point in time, what they'll do is, at best, the investor, what they can get is a 1x return. So if I put in 1 crore and if things haven't panned out the way it has to, the only return that they can get is just a 1 CR of their return of their investment amount.
What is a safe note?
So that's okay. That's the distinction between a safe note and a convertible note. Convertible note, like I told you, it's debt, correct? Safe note is not considered a debt. I'll tell you the key distinction. Here, interest is accrued. For a safe note, interest is not accrued. So today, if you put 1 crore and if you are entitled to receive 100 shares, 5 years down the line, no interest gets accrued. It's just that your shares will get converted, the number of shares that's been given to you or that was agreed at whatever point in time, you will still end up getting only 100 shares. Now, the key distinction also is that there is something known as a cap valuation or a floor valuation basis which these convertible note gets converted to equity. Same thing with safe notes as well. Now, the thing is here for a convertible note, it depends on the valuation that you, on the next round of fundraise. Now, today you are raising funds. Now, in year 2024 you raise funds. The convertible note agreement says that if you are raising funds in 2027, the notes that I have subscribed will get converted to equity. The difference in the safe, with a safe security is that I will tell that my safe note will get converted when you raise $5 million. Now, you can raise $5 million in 2026, 2027, 2028, 2029, whenever. So, safe note doesn't get converted in the immediately next fundraise that you are doing. It gets converted only when the trigger amount has been hit. So, that's the difference. And the thing is, interest doesn't get accrued on it. Sorry? See, yeah, the thing is, like I'm telling you, all of these securities and how you negotiate the terms, barring the legal compliance, but it's purely contractual. So, you can make it akin to a CCPS, you can make it akin to a CCD, go ahead and negotiate what it is. But these are some of the nuances. I mean, the differences is what I'm trying to tell you in terms of how each security works. Yeah.
So let's say investor doesn't get that valuation. Would the equity be converted to that valuation? from safe?
So what happens generally and how investors try to circumvent that issue is that they will specify a floor valuation. They will say that if the company's valuation falls below a particular amount, I want to get out of this company. I don't want to risk my investment here. Pay out whatever it is. Generally, what happens is they'll ask for 1x. Because if the company is not doing good, a pragmatic investor will not ask them, you're not doing good, but I invested 1 crore, pay me 2 crores. The company itself doesn't have the money for themselves to pay salary. Why would the investor go asking for it? So they set a floor valuation. That's what you call as a floor valuation in this transaction document, where if the valuation falls below a certain level, they part ways, but making sure that they receive at least 1x of the investment. At times, I mean, if the company has done horribly bad, there might be a situation where they might even get back little less than 1x of what they've invested, but that's a very hard fought battle between the investors and the promoters. Sorry? See, it depends on why the company didn't do well. See, now let's look at COVID being one of the reasons. Now that's what you call in legal parlance as a force majeure event. Now that is something beyond the reach of a founder's capability. Now he or she is not responsible for their business to go down because of the pandemic. At that point in time, if things don't work out well, now these are the things which are factored in your transaction documents. So one would always look at these force majeure clauses which comes towards the end and they say these are all boilerplate, I don't want to look at it. I mean, it's pretty much standard in all contracts. Trust me, nothing is standard in any of your agreements. Don't ever believe if a lawyer comes and tells you, boss, this is standard, it's time you change your lawyer. That's my honest recommendation. There's nothing standard in your contracts. So you really have to look at each of these provisions, be it in your boilerplate or whatever it is, for you to understand what's the implication on you as a promoter. Also look at the cure period, because generally in transaction documents, if a force majeure event were to occur and if the company is not able to perform at the level at which it was supposed to perform, you can also negotiate for a cure period. Generally in high stake investments, the cure period is actually given anywhere between say 5 to 7 months. Say like a COVID, I mean take COVID as an example. I mean the country came to a standstill for almost about 2 years. Now say if it's a logistics business, they were given that exemption only after a certain point in time, but till then all forms of businesses just came to a standstill. Now what are you going to do about the loss of revenue at that point in time? The investors can't come and tell the promoters that you messed up your business. Nobody could anticipate it. But if the founder were to willingly, say he committed an act of fraud, or he was embezzling money and taking into some other venture or whatever, then at that point in time there is good cause. At that point in time, the founder has to make good the loss. Now even if the company got tanked and sort of got acquired at a much lesser valuation, the promoters will be liable. Now that's the language in your agreement which says the company and the promoters shall be jointly and severally liable. Now you as a layman, if you read that document, you will be like, okay, chalo, I am liable. Now what does the term jointly and severally mean is what we as lawyers will be able to tell you, that it's both company and you jointly together and severally. What does severally in legal parlance mean? Means you individually as well will be liable to pay. Now if I am representing you as a promoter, then I'll tell you, chalo, that's fine. That's the language that is needs to go into an agreement to safeguard the investor interest. But at the same point in time, make sure that your personal assets are not attached. So that's how it is.
Mohit, you want to take an example on the either the write-off from the investor's point of view, or maybe bankruptcy. Take an example of the Byju's, because few things are there where investors have written off nearly 500 million.
What happened there? Poorly negotiated anti-dilution clause. Let me just explain this to you in the context of Byju's and why investors were really ticked off at that point in time is because the anti-dilution. Now, what do you mean by an anti-dilution provision? Anti-dilution provision is if a company were to raise money in the subsequent round at a value lesser than the value at which it raised this particular investment round, you as an investor will be entitled to receive additional shares from the company, just so that your shareholding in the company does not get diluted. And there are two formulas attached to it. One is called a full ratchet basis and one is called a broad based weighted average. I will come into the legalities of this, but long story short, in terms of what happened with Byju's and why the investors were really ticked off, is because the anti-dilution provision was skewed towards the promoter, where there were restrictive covenants that were structured in a way that only limited number of shares were being allotted to the investors for the down round that they raised. And see, generally, when you look at a down round, the down round would be, say, about 10% tops, 10 to 20% less than the previous valuation. This was 90%. So just imagine the value of the stake of the investors, which diluted from where they were to where they came down. The reason being is this, probably because they piggybacked on the reputation that Byju's had at that point in time. Of course, now look at how Byju's as an enterprise sort of showcased itself in the Indian subcontinent. It was just not about making quality education accessible to kids around the country, but also at the same point in time they piggybacked on cricket, which is celebrated in our country beyond anything. So they became the sponsors. Now that's how they showcased. Now why do you think all these investors who put in millions and millions of money into it, why did they do it? Simply because they saw that the company is doing great. The company is also showcasing itself in areas or sectors that is very sacrosanct to the Indian subcontinent. But when it was, all the nasty things was unveiled in terms of how they looked at acquiring business, the sort of downsizing that happened, and lastly, of course, the spite with BCCI which happened, which all sort of led to a decline in the money and goodwill. Now, loss of goodwill also affects a valuation of a company, loss of reputation. Now, and including his brother who was sitting in the US and sort of siphoned money there. So you see a string of activities that have happened here. And the reason why it sort of worked adversely for the investors is because one, it was a poorly drafted anti-dilution clause, which sort of never really gave that protection to the investors. Two, things happened to a level where it was beyond even for the investors, for them. Now just think about the crazy dynamics here. They would have done their diligence, but had they ever seen that his brother sitting in the US siphoning money from here? You never. I mean, they didn't see it, but it happened. Now what happens to that is exactly this. Now look at the situation where the company is in. They got the money in the subsequent rights issue, but look at the liability on the promoter. His personal assets are attached. Now that's how negotiations work, and this was something which the promoter itself agreed, saying that fine, my personal assets will be attached, because there's nothing else. There's nothing. I mean, you can't scrape the bank account of the company. There's nothing there. They've already paid out. They're already in debt. So they have to go behind the promoters. So this is what happens. So in contractually, when we are working on the documents for promoters, where we say that make sure that your personal assets aren't attached, but when mess hits the roof, you really have to add it to it. Yeah?
Thank you.
Okay, so let me just quickly go through. Yeah, this is another point which I just wanted to quickly discuss. What do you mean by disclosures in an investment agreement? Like I just explained to you guys some time back on what representations and warranties are. Just to give you an example, a representation would be that me as a company, I am telling you that, and this is what an investor would want from a promoter as well, where it says that that you as a promoter and the company represent and warrant that you have been in compliance with all provisions of the Companies Act for till the time of your operation, or till the time we are making the investment. But in the previous year, I have goofed up in not filing certain forms with the ROC. So that's where I make a disclosure. So what does a disclosure entail? That means I am informing the investor beforehand, saying that listen boss, I know the representation that you are seeking, but I am also making a disclosure to you, telling you that I haven't made certain form filings in the previous financial year, and this is the penalty that is payable, etc., which the Investors Council itself will decide. Now, what's the reason and why is this disclosure made? It is to ensure, one, transparency between the investing company and the investors, telling them what the current situation of the company is, right? Because it also is a matter of good faith and trust, which is very important in an investment transaction. Now, just because I disclose this matter to you, does that mean that tomorrow if a claim is made, that the promoter is not liable? No. The answer is no. It's just that these disclosures will be built into something known as a disclosure schedule in your document, where any non-compliance with respect to the representations and warranties that have been made will be disclosed in that schedule. Now then the investor will take the call, saying that which of these non-compliances can you fix prior to our investment, which of these non-compliances can you fix post-investment, right? So that's the reason why this disclosure schedule is included into a transaction document. But then again, if we are representing promoters, what we generally try to push for, and if the investor is also considerate enough, is to say that we'll make the disclosure, but please don't hold us liable. I mean, if we get that, it's a win for us from an investor, but if the investors say no, it's perfectly fine. Yeah, I think CPCS I have sort of taken, and just for everyone's knowledge, I will be sharing the slide deck with you because it's fairly text heavy, but I just thought I'll take you through the entire presentation, and then later if you have any questions, it's pretty much there in the slide deck, which you can use this for your reference. But if there's any questions that you have, please feel free to ask. Indemnity and limitations. Yeah. Now, shareholders agreement. Now, these are the rights typically that are seen in a shareholders agreement. Governance of the company, that's board of directors, information inspection rights, investor reserved matters, transfer of securities, right of first refusal, preemptive, anti-dilution rights. Now, sounds like a lot of legal jargon to it, but to be honest, it's quite interesting. Governance of company. Now, what do I mean by that? Today, if I'm an investor and I make the investment in your company, I would ask for a board seat. Why would I ask for a board seat? Is because so that even I am privy to to understand what's actually happening in your company. But the board seat that I get as an investor is a non-executive board seat. That means I do not have an executive role where I cannot pass resolutions which is related to the company's business, say for example appointing an auditor of the company. That's not my role. That's called a non-executive director. The only reason why investors ask for this is simply because that they have a seat on the board and they know what's happening in the company. Now, from a startup standpoint, what can you negotiate? Do you think that it's right for you to bring an investor on board immediately just because they're putting in money? Maybe, maybe not. Why not is the question. Why not depends on how much investment that they are making in the company. 2, what is the value add that they are bringing to the company? Are they also helping you in strategically building your business? Do you think that this particular investor should be on the board? If you feel no, or if you are bringing this investor purely for the purposes of getting that funding push for your company, there's something known as a board observer. Now, who is a board observer? The difference between a board observer and a person who's been appointed on the board is voting rights. Observer does not have a voting right, but observer will still sit on the board and he will be privy to what's happening around. But giving a board seat is different from having a board observer. So, a board member will have the right to vote, but here they will not have a right to vote, right? So, that is something, so that's the key distinction. Of course, the other bit is, if they do not ask for a board seat, you don't have to give them a board seat, but that's hardly the case. The least that any investor would ideally want to have is a board seat. Information and inspection rights, it's fairly clear with what it actually says, that essentially the investors will have the right to look into your books, books of accounts. Now that would be looked at quarterly, half yearly. That's something that you need to discuss and agree with them. Other than that, what's your business plan, what's your customer acquisition strategy, who are the suppliers that you're working with. So there are n number of things that are related to your company's business and operation, which they can review at a particular interval that you agree upon. Okay, this is fairly critical, which is where the investors come and ask you, boss, I have put in the money here, and this again, like I was telling you, it depends on the quantum of investment that they have made, and also depends on the shareholding that they have in your company. See, reserved matters is not something to be taken lightly by promoters. The reason being, see, these are some of the reserved matters that are typically captured in a transaction document, where the investor says if the company is taking any decision, say with respect to modification of the capital structure. What's modification of capital structure? Essentially, you bringing in new investors, or any deviation to the company's business plan, liquidation, dissolution, or winding up, or even acquisition for that matter, any related party transaction, or change in the charter documents. What by charter documents, meaning your memorandum of association and articles of association. What it's essentially, what do investors say is that if the company is taking decision on any of these matters, you need my approval. Without my approval, you cannot pass any of this. So this is not something that you should take lightly, and you ideally you wouldn't want to give it to any and every investor who's coming in. Now, you are a company who is valued at 10 crores. Tomorrow I just feel that, okay, listen, you're a good friend of mine, I'm just going to put like 5 lakhs of rupees. Are you going to give me reserved matters? No, it makes absolutely no sense. And what is it that's important for promoters to keep in mind, especially with respect to this, is that you negotiate and you tell the investors, the day your shareholding in my company falls below 5%, your affirmative voting right just falls off. So today you own 10%. I go ahead, raise fund 5-6 rounds of funding where your 10% gets diluted to 4.78. Once your shareholding is less than 5, you do not have a say in this company. The reason being, for me reaching 10 crores, my company's valuation also would have jumped up twice, and the kind of investments that I would have received would be a lot higher than what you would have invested at whatever point in time. So you enjoy the right for whatever point in time that you made the investment and you were critical to my business. But again, there are other investors I need to answer to. Transfer of securities by investors and promoters. This is, just understand this, investors are free to transfer to anyone at any point in time, provided that the transfer of shares does not happen to a competitor. The only exception that lies is if the company does not give them an exit within the agreed period of time, only at that point in time that restriction falls off. So because the investors want to look for an exit. Now promoters, again, transfer of promoter shares are subject to investor consent. Like I was explaining to you, the entire process of lock-in and vesting. They will lock in your shares anywhere between the range of 3 to 5 years. They will say shares get vested annually over a period of time, and liquidity, like I said, 5 to 7% of your shareholding you are free to transfer among certain third parties or whoever it is, just so that there is some cash liquidity for you, nothing beyond this. Termination of promoter's employment, I was just explaining. One is a good leaver, bad leaver situation, and termination by the company. Good leaver situation essentially means it's a gentleman's shake hand, that you as a promoter have done fantastically well for the company. You want to pursue something else, or be it for personal constraints, whatever be the reason, you decide to part ways with the company. What happens at that point in time? The shares vested with you, this is just an example, so this is not something that's prescribed by law. I'm just showcasing some of the terms that we typically see in transaction documents. What happens in the event of a good leaver situation is that the shares that are vested with the promoter will continue to be with them. The unvested portion can get either transferred, be bought back by the company at whatever be the valuation at that point in time, or be transferred to an employee stock option pool, that the company has set aside, or be transferred to a third party as may be nominated by the company. What's a bad leaver situation? Commit any act of fraud, willful misconduct, anything of that sort, which where it is conclusively proven that the employee has, the promoter has defaulted in carrying out his or her obligation. That time even the vested shares gets reverted to the company. And what happens at that point in time is they won't be given that benefit. Say for example, the company when it started, the valuation of the company was at 1 crore. At the time of a bad leaver situation, the company's valuation is at 10 crores. Does it mean that because I committed an act of fraud, I can exit from this company by selling my shares at a 10 crore valuation? No. That point in time it will be bought at face value. What's the face value? 10 rupees or 100 rupees, whatever was paid at that point. And even the unvested portion gets sort of routed back to the company. Last is termination by company without cause. Where the company says, boss, you leave, go ahead, explore whatever it is, it's just that we can't afford to pay you, or whatever be that reason. But the employee or the promoter has performed his obligations very well. And what happens at that point in time, both vested and unvested gets accelerated. Because you stand to, you are ideally entitled to receive the complete benefit of the shares that you are actually holding, and you are not leaving the company is asking you to leave, right? Right of first refusal essentially is when provides a non-selling investor with the right to purchase shares from a selling shareholder at the same valuation. So essentially how it works is, today I am an investor in your company, I want to sell my shares. There's a third party buyer who has agreed to buy my shares at 200 rupees. Now, right of first refusal is essentially what I'm going to do, that is, or the right that is that it entails is that the existing investor, if the other investor or the other shareholder is willing to buy it at the same price at which what the third party has agreed to purchase it from me, I make the offer to them. If they refuse it, that's called right of first refusal. So they have the right to first refuse it. Only if they refuse it is when I can go ahead and sell it to someone else. What's the economic rationale for it? It grants the investor with specific control over who might join the cap table. So if you don't like person X joining the cap table, then because I would have to tell you what's the offer that I've got from the third party whom I'm intending to sell and who this third party is. Then you have tag along right. Tag along right, in a nutshell, it's essentially a right given for minority shareholders. It sort of safeguards minority shareholders, where if a promoter wants to sell his shares, the share, and you can draw sort of a number attached, you can attach a number to it. If 50% of the shares of the company are being transferred, then you as a minority shareholder have the right to tag along with the shareholders to sell your shares. That's what tag along means. Preemptive rights is also if the company is raising future capital from a different pool of investors, the right is given to the existing investors to see if they want to purchase or further subscribe to securities in the company. I'm just going to quickly go through this because I think I'm a little too late. Anti-dilution, I just explained it to you. There's a whole formula attached to it. I will explain this to you slightly later. It's very simple. In a nutshell, two types of anti-dilution rights: full ratchet, broad-based weighted average. What's a full ratchet anti-dilution? Today shares are issued in my company at 10 rupees. 2 years later, I do a down round where shares are issued at 5 rupees. So what happens at that point in time to the existing investor? Additional shares should be invested to that investor at 5 rupees itself. So that what will that lead to? The promoter, that's me, I will lose, my shareholding gets diluted big time. In a broad-based weighted average, there's a particular formula attached where basis that formula, it won't be a flat discount, but rather a small percentage of it gets attached to it. Non-compete and non-solicit restrictions, essentially what it means is, when you are a shareholder in my company, I will not partake in any competing entity. Non-solicit is that even if I venture into some other different profession or explore other avenues, I will not solicit the existing employees or the customers of the company. Liquidation preference we discussed in terms of what happens in the, what's a liquidation event? Acquisition, merger, dissolution, winding up, whatever happens at whatever point in time. Then what happens to the proceeds? The proceeds is essentially goes to the guys who have debt, and then convertible preference shares. Last comes your equity. Timing and structure of exits. These are exit periods varies in terms of what's been agreed with the investors and the promoters. Different forms of exits, IPO, strategic sale, third party sale, yeah, these are some of those, and even buyback, that's buyback by the company. Last, the final form of exit is the drag along right. So this is the last exit provision that you see in a transaction document, where if the company and the promoters fail to give you an exit within 5 years or 10 years, whatever you have agreed, and the investors have also tried to do a strategic sale where they try to find some other buyer, but it just doesn't go through and they are not able to get the returns, then the drag along right essentially provides the investor saying that they will find another third party buyer at whatever be the price. It can't be, it need not be 5x the return, can be 1x as well. We as promoters and all the other shareholders are being dragged along by the investor to make that sale. So I think that's that. I mean, the last bit I sort of rushed through.
And now the Q&A which had to be taken at the end, it might have already gone in the beginning stages itself, and we really appreciate the questions which were posed by the audience before the first half of the presentation itself, and we from TiE Mysuru extend a very warm greeting and a heartfelt thanks to the speaker who made all the queries being addressed at that particular stage itself. So now I request Dr. Mahesh Rao sir, the president of TiE Mysuru, to render a heartfelt thanks and gratitude, a token of appreciation to Mr. Mahit Anand, and I request you to be on the dais, please. There will be a series of workshops which will be taken, in the coming stages, where probably, particularly to the associate members or the students, where the sessions would definitely be of a very great help. Thank you so much, sir.
Thank you so much.
Or in number from various institutes participating at their high enthusiastic energy. Dear students, kindly make a note of it. There is an announcement being made from the SJC step, which goes with the core competency of supporting the students. So we have Mr. Shivshankar sir here, who is the CEO of SJC step, making the announcement on the MSME Idea Hackathon 4.0.
Yeah. Thanks, Kishan. Mahit Anand, thank you very much for the wonderful session.
Yes.
So with your permission, definitely I'll use all your slides like Bible to most of the startups coming to my office and then seeking most of these informations. So with the rights.
No, it's fantastic actually. STEP was one of the first places where even I sort of came into Mysore and tried to build a practice there.
Fantastic, right. Okay. Definitely, these are the fundamentals most of the founders and entrepreneurs potentially ignore. Probably that's what I'm telling, because they're in a rush to do their idea to the next level and things like that. So eventually they end up in compromising to quite a bit of a levels. So that's why we try and educate most of the time, understanding why the compliance is a very much important part of it. Right. Thank you very much once again, giving that wonderful workshop for all of us. Right. It is an opportunity to most of the students, the innovators, and registered startups. Considering the TiE University is also coming up in 2025, and again we are going to be TiE is part of the representing from Karnataka, and I don't know whether TiE chapters can be or not. Another opportunity before that, MSME Idea Hackathon. It is open to students without the company registrations, and for the innovators again without the company registration, and plus the startup who are having a registered entities as well. Simple 15 lakhs grants. Those who are able to qualify that particular theme which they are able to roll in this year. There are 4 themes. Effectively, they have highlighted this particular hackathon. PM Vishwakarma, under that 18 trades are there. If somebody is sitting in Mysuru, there are all the 18 trades are there in Mysuru. Every arts, crafts, and you name it, all of that available. If somebody is sitting here and looking to capitalize on that an idea and build a business, fantastic opportunity. And frontiers of the technology in MSME, typically on all latest technological things, AI, ML, IoT, cybersecurity kind of a thing. That is a category which fits into it. Then the fourth one is export enhancement. Basically, it is if you have a product or idea which is replacing any product which is importing today to India, if you're able to crack that product category. The fourth one is sustainable development, is completely focused on green energy. If anybody in that particular sector. But put together, there are thousands of ideas you can create. 26 is the last date for the submission. While submitting, you need to choose incubator. In Mysore region, SJC STEP is one of the enabling entity to qualify as a first level application processes for all your ideas. Right. So that's the main aspects of that. Where do you need to submit? The link is there in the next slide. Okay, again, eligibility criteria, 18 to 35 years, and student, MSME innovators, and then the startups. Please make a note of that. I think I need to ask the MSME ministry itself. See, it is purely promoting, you look at all the themes this time, promoting that young innovators, idea generators, those who want to get in and then try it out. So money is available, so give an opportunity for yourself. That is an approach, that is an intent, effectively. This is the first opportunity somebody can really try before the next TiE coming in, or maybe other opportunities coming for next 6 months. Series of schemes are going to roll out from the government, especially from almost from July to January. Almost all the schemes will be rolled out from the central government during this time period. Roughly, whatever I've seen from the last 7 years, roughly most of the schemes things are rolled out from this June to and almost to January. So that is the time period. MSME is also coming out. Is a 26th of September is a deadline. Please make note of it. Next slide. Slide is okay. Any questions? You may reach out to us. We are happy to support on you. So take this as a grand opportunity. 15 lakhs is a good money to think about, to give an important strength to your idea itself. Thank you very much.
Thank you, sir. I think, Anil, beyond 35, 15 lakhs is not enough. You have to go target greater than that. Jokes apart, I hereby make my concluding remarks by thanking Dr. Mahesh Rao for taking us to Jog Falls and briefing out about the Sir M. Visvesvarayya's contributions beyond Mysuru as well. I thank Ms. Aditi Puranik for introducing the the guest for today so graciously. Thank you so much. I also thank all the institutional partners who are who made this event a great success by sending their all student members. I extend my greetings to all the associate members and charter members of TiE Mysuru as well, especially to quote Mr. Mahesh Katala, Executive Director, for coordinating and organizing this event. The venue support being extended by the Leruchi as well as the inside out consultants for making all the facilities available in time. So we hope we have very good networking dinner, and all the Q&A part, which might be a due factor, will definitely be addressed by Mr. Mahit during the dinner. And also he is openly given the sort of information that he is ready to mentor each and every individuals if one-to-one mentorship is required. So thank you so much everyone. Have a great networking dinner ahead. Good night.